Are you ready for me to call the judges?
Yes.
Okay.
Yes.
Just like to remind everybody to please silence your cellular devices while we're proceeding. All rise. Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in the case of Ponderosa Fire District et al. V. Coconino County, Board of Supervisors, etc. Our civil number 13-0545. Each side will have 20 minutes within which to present their arguments here this morning. Appellant may preserve some portion of that time for rebuttal. However, it's up to you to keep track of that time. We have a digital clock at the podium. If you tell us in advance how much time you think you'd like for rebuttal, we'll try and remember that and remind you if we have that chance. We have read the briefs. We're familiar with the record. We've reviewed the amicus submissions and responses. We have conferenced the case, so we're familiar with the underlying facts and the legal issues that you've brought forward here today. So please take that into account as you make your arguments here this morning. We are recording this argument, both in terms of audio and video. So as you approach the podium, please identify yourself and your clients for us and for posterity, because the video at some point will be posted on YouTube and for all to see. With that, appellant, you may proceed.
Good morning. My name is Cameron Artigue. I'm here on behalf of Coconino County. I would like to save 7 or 8 minutes for rebuttal if I'm able to do so. Most of the briefs is about text and may versus shall and canons of construction, and that is certainly front and center of what this appeal's about. Personally, I think the briefs do a pretty good job of discussing those issues. So in my time here this morning, I want to take a step back from the text. I have not had a chance to sort of comment on the amicus briefs that have come in because they came in on our side. And I want to, the one point I want to make here this morning is why it is so extraordinary to suggest that a local government becomes financially responsible for the completion of subdivision infrastructure when it approves a subdivision plat. Because that is really a novel and extraordinary proposition. Oftentimes people think that local government builds subdivision infrastructure. Local government does not build infrastructure in new subdivisions. When you drive out to a new housing development, people will think, oh, well, the fire department must have put in those hydrants and the city streets department must have built the streets. Local government does not build that stuff. They are not expected to build that stuff. They do not budget to build that stuff. That infrastructure is all built by private parties with private money and then dedicated as a condition of subdivision approval.
Counsel, let me ask you a question.
Yes.
Let's look at a different scenario here. This is not the scenario in this case, but let's look at a little different scenario. Let's say that Empire had gone forward and had gotten further along in the construction process and actually built some homes and sold some of those homes to individuals in the public. And they're in the subdivision, and Empire defaulted, and the roads weren't completed, the utilities weren't completed properly. They defaulted, they walked away. There's no new developer that's going to come in and finish the project. And so the county is faced with a situation where you have people living in the subdivision. There are health and safety issues, and the developers walked away. Would the county then have an obligation to call the bond on behalf of those residents in the subdivision? Let me phrase it even more clearly. Would it be an abuse of their discretion if, under those facts, they did not call the bond?
An interesting question, Your Honor. Of course, my answer is that it remains at all times a discretionary decision. Just like whether to sue a vendor for breach of contract is a discretionary decision. At some point, can we hypothesize that it becomes an abuse of discretion? I suppose, sure. That's the essence of special action relief. But, it is akin to a decision to, should we file a civil lawsuit against the contractor? It is very much a discretionary decision. And this is, of course, not the case where you have an abuse situation. That's not the theory that's been pled or tried, or the theory on which the case comes up on appeal. And there's no case that says there's an abuse of discretion here. The starting point here is not that there's a county obligation to build infrastructure. The starting point is that there isn't. And what the bond is a piece of equipment that enables the county to come to the rescue, to become a good Samaritan in a given situation, like Your Honor suggests, if the situation warrants it.
Well, I'm sorry, Counselor. That's why I asked you that question. I know that you argue the county doesn't have an obligation to complete infrastructure. But if, in fact, it could have been an abuse of discretion under the scenario I described, doesn't the county at some point have an obligation to protect the health and safety of residents of a subdivision? Or they have zero obligation. Under that scenario I just described to you, they could say, no, we're not calling the bond. We don't have any obligation to call the bond.
Judge, I think you have to imagine a really sort of a lawyer's game sort of hypothetical to make it an abuse of discretion. Yes, if the subdivision's all built and the key to turn on the sewer has been lost and it costs 99 cents at Home Depot to go buy a new key, and the county says, we're just not spending that 99 cents,
well,
that might be,
What I'm getting at is you say the county has no obligation regarding these subdivision improvements. And it seems to me at some point, if it could be an abuse of discretion not to call the bond, they do have some kind of obligation to protect the public from hazards, and there's some safety issue, some public health issue.
Well, yeah, but this is not a tort claim. And the Board of Supervisors has the same duty to protect the public that they have in any of their administrative capacities, in setting a capital improvement plan and in setting the tax rate. And once you start saying, oh, we're going to see this particular decision as an abuse of discretion, you really get separation of powers problems here. Because the county's obligation is to think about the whole county.
I guess, isn't the crux of your argument that it's not the county never has an obligation, but that it has the discretion to decide when?
Yes, absolutely. Yes, the bond is an emergency source of funding. It's like a fire extinguisher. And if the county chooses to do something which it doesn't have an obligation to do, and which it didn't plan for and didn't budget for, if it chooses to say, hey, this is a time and a place because of health or whatever reason, we need to step up, yeah, that's why the bond is there.
And that would be a factual issue, right?
Yes.
Okay.
Yes. I think it would be a factual issue. And as we set forth in the briefs, you can imagine 27 different variables that inform this decision. Who's going to benefit from the infrastructure? Is the bond adequate? Is the bond company solvent? What's our financial position here at the county? Is the infrastructure in question, is it to complete some critical missing link in our transportation network, or is it out in the forest somewhere? Is it one guy or is it 1,000 people? It's like a bunch of other decisions, that boards of supervisors make all the time. And in my briefs, I talk about the buck stopping somewhere, and it stops with the elected board of supervisors. It has to.
So let me ask a little different question. As I understand, a part of your argument, the county's position is that Belmont, having acquired these lots, any obligation to put in the infrastructure would lie with Belmont as a developer or subdivider. Is that a fair?
That is true.
What if the situation where it was 10 different owners or couples bought these lots and wanted to build? Would the county's position be, well, individually or collectively, it's your obligation to put in the infrastructure?
Well, I think the distinction there, Your Honor, is between consumers and sort of successor developers. I mean, yeah, this was bought out of bankruptcy by a single real estate developer. It could have been split up in the bankruptcy auction. And the Norton case says, that's consumers. That's plain folks that own lots in a subdivision and the infrastructure wasn't built and their lives are negatively affected.
So if they own less than 6 lots, they're just consumers?
No, I'm saying I think that we can all agree that the law, that consumers are protected and sort of it's good to protect consumers. But even when consumers have purchased the lots, which is the Norton situation, the Supreme Court says this is still a call for the elected board of supervisors. Plus, when you have a subdivision where the infrastructure hasn't been built, you generally will have a developer responsibility and ownership of the common areas. And if there are any unsold lots, that will usually transfer with. I guess all my answer to your question is illustrating, Judge Winthrop, is how complicated, how every case is different. And how you cannot say as a matter of law that, whenever something bad happens, whether it be a bankruptcy or a flood or a fire or a strike, that there's an obligation to call the bonds and complete the subdivision improvements. No city attorney, no county attorney has ever given that advice to an elected representative. Subdivision plats are approved all the time by the units of local government within this state. And it has never crossed the mind of any of those elected officials or the budget managers or the bond council that when we tell KB Homes they can build a master plan community in our jurisdiction, that we're getting in bed with them. And if they go bankrupt, it's on us to build out that entire subdivision, to make it ready to improve all the lots so that whoever buys it out of bankruptcy can make a lot of money. That is just no county attorney, no city attorney, it's never crossed their mind.
You've sent, you were required to send the resolution to the surety, and so the board passed a resolution
Yes.
that the subdivision Unit 3 was not complete.
Yes.
And then they sent it
Yes.
to the surety, so calling the bond. I couldn't glean from the record. Has anything happened with that?
This is surety ignored it. It was sent. The surety was served, and I think this is in the record. The surety was named as a defendant in this lawsuit, appeared, moved to dismiss. So, the surety's not paying up. I mean, we all know what's next. The next stop down the road, and Mr. Freeman was candid about this in the Superior Court, was, the next, step 2 is let's make the county file a civil lawsuit against the surety.
You'd have to sue them to make them pay up on the bond and for damages. Okay.
Yes. And
hold on one second, Counsel.
Go ahead.
So, as part of the relief in this case, are you asking, are you seeking, if you succeed on appeal, to then pass a subsequent resolution, or is your board seeking to pass a subsequent resolution revoking the resolution calling the bond and reaffirming the resolution that refused to call the bond. Where do you want to go with this now? Because you've already passed a resolution and sent it to the surety.
Right. What I am seeking, the relief sought on appeal is reversal of the Superior Court's judgment and either A, instructions to grant the 12B motion, or B, for further proceedings consistent with this opinion. Because there are claims that remain in Superior Court. There's a fee claim, and what remains in Superior Court are claims to force the county to go out and issue contracts or roll the public works cement trucks and go start building streets. So a decision that says this is a discretionary thing, remand for proceedings consistent with this decision, I think will, I'm not asking the Superior Court to order any new or different resolutions. That's kind of inconsistent with our theory of the case.
So you don't need that to protect your interests because the surety's otherwise ignored you?
Yes. Yeah. No, the surety is clearly not going to pay up. And I will sit down with that point that, look at what the next stop down the road is. Because the next stop down the road is either for the Superior Court to tell the Board of Supervisors to initiate and prosecute a civil case, which is, there's a real separation of powers problem with that, or to order the Board of Supervisors to adopt a budget and to raise taxes to go start building roads on private property somewhere. And there's a separation of powers problem with that. So thank you. I will reserve the balance of my time.
Thank you, counsel. Mr. Freeman.
Good morning, members of the panel. May it please the court. My name is Shelton Freeman, and Mr. Matthew Manfield and I represent the appellees in this case, who are the Ponderosa Fire Department, 3 of the homeowners associations that are in existence in the Flagstaff Meadows subdivision, which Unit 3 is comprised of, and Utility Source, which is the utility water provider that issued the right to serve letter for the water rights for the subdivision. Unless your honors have some points about the procedural context that you would like me to address, I'll respond to counsel's comments and hit what I think are the beef.
Please proceed.
Thank you, Your Honor. First, I want to point out there's been a serious misrepresentation in this record. The surety didn't not respond. The county sent a cover letter with the resolution to the bonding company saying, you don't have to do anything on this. We're appealing it and we're going to win. That's where things stand with the bonding company. There has been no action with the bonding company because they were told they didn't have to do anything. The bonding company filed a motion to dismiss in this case. We opposed it. The county took no position, and the judge granted that motion to dismiss.
So if we were to grant the county's appeal and say they had discretion and they didn't abuse their discretion, do we need to do anything more than what Mr. Artigue has suggested?
I wouldn't believe so, no, Your Honor.
Okay.
More importantly, Your Honors, what this case is about is what the legislature did in 821 and its predecessor. And what's been lost in the confusion, apparently, is the fact that after the land debacles in the late 60s and early 70s with the Ned Warren types and the others, the legislature said, we're not going to let this happen anymore. We are going to require counties, who they had delegated subdivision authorities to, it's mandatory that you shall require assurances sufficient to ensure completion of subdivisions. Okay? 1975, that happens. The Anderson case happens right when that statute's coming down. And the court there, Pima County had tried to impose that requirement before the statute went effective. And the panel said, no, you can't do that because we apply strict scrutiny and you didn't have the authority. But in the dissent, it makes it clear that this is a clear mandate to every county in the state. It's no longer discretionary. You will make sure subdivisions are completed. What's ironic is now we have the county standing before you. The statute is clear. County, you shall require these subdivision assurances if you're going to approve a final plat before the improvements are done. And mind you, the improvements are the infrastructure improvements, the streets, the roads, the sewer, the water, which is exactly what the amendment to 821 was about. It was about ensuring to whomever buys a lot in a subdivision, whomever buys that lot knows they're going to get water. In this state, that is critical. And in fact, this statute 822 specifically requires the county, when it approves that plat, it has to stamp on it.
Counsel,
Oh.
you've argued this is a ministerial duty. That means that the county must call the bond once that final plat is approved and you have a defaulting developer, no matter what, under any circumstances. Is that your argument?
They have other options, Your Honor. They can revert the land, they can revert the final plat. If they decide this subdivision shouldn't go forward, they have that authority, and Canino County has that authority.
But under this statute, they have no discretion, no matter what happens after that plat is approved, no matter what the circumstances are, they have zero discretion as to whether or not to call that bond. Is that your argument?
It is my argument, Your Honor, and here's why. They have the absolute authority to require that all improvements are completed before issuing that final plat. That's absolutely in their discretion. They are given the option to go ahead and issue a final plat without those improvements, but only if that they require assurances in a sufficient amount to ensure completion. That is the exact language in the statute.
Where does it say in the statute, where does it specify under what circumstances the county has to call the bond?
Your Honor, in 821 itself, 821C says, the regulations shall require the posting of performance bonds.
I recognize that.
And
They
it says-
have to require in their regulations that a performance bond be posted. It also states that that performance bond has to be adequate enough to cover the cost of the improvements. Can you show me where it says they have to call the bond?
Yes, Your Honor, where it says necessary to ensure the installation.
Doesn't that modify the amount of the bond? In other words, if you're going to post a bond, we're going to require that it's enough to cover the subdivision improvements. Where does it say you have to call that bond?
Your Honor, it's right there in your face, and I had to step away from this to understand it. But if you think about it, if the subdivider defaults, who did the legislature put in charge of the subdivision?
How about a new developer that comes in that wants to build the subdivision? Isn't that the obligation of a developer, is to pay for the cost of improvements?
Absolutely. The original developer, and this developer did pay for those.
Well, let's say Empire, the day the final plat was approved, it was approved by the board at 9:15 in the morning, and they walked out at 9:20 and sold the subdivision to another developer. Are you telling me that that new developer comes in and says, I'm not paying for any improvements? That's a bond that was posted by Empire. That's not my obligation. You better call that bond.
Well, let's be clear, Your Honor. The subdivider in the final plat posts assurances to complete the improvements. And let's talk about what improvements are. Again, improvements are the streets, the curbs, the utilities. That bond compels, there is the assurance that it's going to be completed, regardless of what the contractor does. He could sell it 5 minutes before he walks out. If he is contractually obligated to perform under the plat, the subdivider has that obligation to the county.
So your position is, counsel, that if Empire had sold this subdivision 5 minutes after the final plat was approved, the new developer would have zero obligation to pay for the improvements. The county would be required to call the bond immediately. Is that your argument?
No, actually it's not. We need to break that down, Your Honor. There's several elements there. One, Empire's still on the hook to perform those subdivision improvements. They don't get released from any obligation under the plat to perform that. Let's talk about what's being sold. If the lots in the subdivision are being sold, that frankly happens in a lot of the major subdivisions where they'll bring in different home builders to buy those lots. That's not uncommon. That doesn't release Empire from the obligation to perform. And Empire had to write a big check or post a lot of money as an assurance to make sure those were going to get done. And that money's sitting there for that exact purpose.
The county has no discretion to consider the development or let me choose a different term, the fact that there's now a new developer that's coming in and wants to develop the subdivision? What if you had a situation, which is very close to this case, where a developer came in, posted the bond, the final plat's approved, they default, they walk away from the project. They haven't really constructed anything. And there isn't anybody who buys a lot or a developer for 50 years. Are you telling me that the county has a mandatory ministerial duty in 2014 to go finish the roads, finish all the sewage, finish all the water, all the electrical, or call the bond to do that, and then just let that subdivision sit there until somebody comes along?
No, Your Honor, they can revert that acreage back to its prior zoning.
Well, then this isn't a ministerial duty, because what you've argued is that this statute leaves them no discretion. They must call the bond once the plat is approved and the developer walks away from the project. That's a ministerial duty. One thinks of Marbury versus Madison. Here are the appointments of the new judges. You have to sign them. You don't have any choice. That's mandamus. That's a ministerial action. That's what you've argued.
It is, Your Honor. For them, in this situation, if you look at the exhibit we've provided, this subdivision isn't going anywhere. It's not one of these random subdivisions. This is Unit 3 of an existing subdivision. Talking about developing the improvements are subject to restrictions that are in the plat. So any contractor can go out and perform those, and they have to meet city standards or county standards. It's not like somebody can just show up and do a shoddy job. That's exactly why those assurances are there. But if you take your argument and you flip it over and you say, okay, well, it's okay to charge another home builder the $4.2 million, well, what's that do to the housing prices? Why should the citizens of Coconino County be forced to pay more for their home because the county wouldn't use the exact funds that were segregated for that purpose?
Who gets the primary benefit of that $4+ million bond, counsel?
The Ponderosa Fire Department gets $660,000 of that. There's a specific bond for the improvement of fire protection.
Or than the developer? Because normally, if the developer were the original subdivider, they'd have to pay for all of that.
They did. They posted these bonds for that exact purpose, Your Honor. I guess that's what I'm saying. These funds are there. They're not county funds. If this were a cash bond, the county couldn't just take it into their coffers. It is posted in trust for the specific compliance under the statute to perform their duty. If they're not required to ensure completion, then nobody is. That wasn't the legislative intent in the 70s. The legislature made clear we are not going to have unfinished subdivisions in this state anymore. We're not going to have people having to buy lots in a subdivision that they don't know they're getting water, they don't know they're getting utilities, and they don't know they're getting proper streets.
So, counsel, you want to place the duty on every city and county in this state when a developer defaults on a subdivision to call the bonds, and they're required to finish every single improvement in every single abandoned subdivision in this state? That's their duty?
They should never have approved them. It's not my duty that I'm putting on it. The legislature made clear in 821 that it is their duty to do that.
It made that duty clear?
I believe so. It did, Your Honor, because it requires ensuring completion of subdivision improvements.
Could the county now revert the Unit 3 of the subdivision?
I think they could take proceedings to do that, yes. I think, given the facts, I don't think they would be successful, but yes, I think that is an option. And I think, despite the statutory language, if a final plat is approved by a municipality and it remains in place, then a county's duty is to complete that subdivision. If they revert the final plat, that extinguishes that obligation. So I believe they do have options. The other option is to avoid this situation by saying, we're not going to approve final plats until the work's done. That eliminates the risk and that eliminates the burden. But for a county or an amicus to stand here and tell Your Honor, we didn't know, I'm sorry, Your Honor, the statutory provisions make it clear. No subdivision should get approved unless there's done or there's money there that you have decided in reviewing all the factors that you have to review to approve a final plat, which are significant. Gather all that information, you can approve it, but then we're going to give you the discretion to just say, oh, no, we're not going to call the bond. Sorry. Sorry, Ponderosa Fire Department. You wanted to give extra protection to your community from third-party funds. We're not going to do that for you. Sorry, homeowners, your utility rates are going to go up double because we're not going to allow this other unit to be developed. Sorry, lot owners, we're going to force another $4.2 million in costs on you because you happen to buy those lots. And we don't want to call these bonds that we got. That is not what the legislature intended, and that's not a standard that this county should be able to apply in this case. There are situations where, in this instance, yes, we have the parade of horribles. Gosh, if we force cities to actually do what they were supposed to do, that could be bad. Well, Your Honor, that's hypothetical. We don't know what those situations are.
It's hypothetical that developers will abandon subdivisions and not have enough money to finish them? That doesn't happen?
Your Honor, it should.
It shouldn't happen?
That's correct. If they do their job correctly, they will obtain enough assurances that if that subdivider fails, they've got the money to pay for it. They are given all the tools in the world by the legislature to say, we want cash bonds, we want a surety, we want you to finish. Gee, contractor, we're a little unsure about your financial. You have to finish the improvement before we're going to give you a final
What if it
plat.
sits vacant for a while, counsel? Doesn't the cost of labor go up? Doesn't the cost of materials go up? How can you anticipate those things?
That's the job of the community approving the final plat. That is part of their.
So counties and cities are the guarantors for the completion of all developments.
That's what the legislature has said in 821. They want to ensure the completion of subdivisions.
So just so I understand what you're saying, in Judge Gould's hypothetical where the development was 25 years ago, and let's assume that statute was in existence then, and the developer posted the bond and the plat's approved, and then goes out of business and it sits there, and 25 years later, there's a new developer comes in and wants to do this and reminds the county of some obligation to call those bonds, which are now completely inadequate to cover the cost of putting those improvements in. Is it your position that the county then is responsible for the difference?
Your Honor, under that scenario, I would say no, because if I were the county, I would revert that property back to acreage and force that subdivider to come in with a new plat, because after 25 years, I'm confident the building standards had changed, and any improvements that they would be installing would be required to meet a different level that were in place at the time they approved that subdivision plat. So it is not an absolute, but it's also an obligation that the legislature has imposed on municipalities. And if the county isn't responsible, then no one is. And that's, again, that's not what the legislature intended. And
But if the legislature wanted to, it could have said that explicitly. In the event of developer default, the county shall call the bond.
I guess it could have gone the extra mile, but by making it mandatory that you shall require assurances, Your Honor, the case law in Arizona is clear that when funds are placed in a bond for a specific purpose, they're held in trust by the municipality holding them, and they're to be used for that specific purpose.
Counsel, the very idea of a trust implies discretion by the trustee.
Oh, not at all, Your Honor. Not in this instance. The legislature made clear that those assurances were to put in those improvements. And let's be clear.
But separate and apart from that, you keep talking about they're put in trust. The fact that they may be in trust doesn't mean that the county doesn't have discretion on when to call the bonds in and of itself. Now, I know you believe that the statute says they're in trust and it's mandatory that they have to call the bonds. But I want to be clear about that. Using the word trust doesn't mean there's no discretion.
I agree, Your Honor. What it says, though, is they don't have discretion to do something else with the money. Okay. They can't use it to pay their regular operating expenses or other municipal obligations. Those funds are held in trust for these specific tasks.
Is that an issue in this case? Is the county asking to revert these funds to the general fund or to use them for some other purpose?
They're asking to ignore them. They're essentially asking to let the bond loose, not have to collect it.
My question, counsel, I'm asking you, has the county once in this litigation said they want to take this bond money and use it for something other than the subdivision improvements?
No, Your Honor, they have not. Their position is that they're not obligated to call the bond and use it for that purpose.
Has the county said they wish to release the bond or discharge the bond or waive the bond?
Your Honor, they've made it clear they don't intend to pursue it. You heard counsel say here today they're not going to pay. So yes, I believe their clear intention is not to collect against the bond.
All right, but if my question was, have they said that they are going to release the bond or discharge the bond or waive the bond? And
No,
they
Your
said
Honor.
that.
And in fact, if you recall, our initial relief that we sought from the trial court was simply that. Send the resolution to the bonding company because that triggers their responsibility. That was the scope of the relief we sought. That is exactly the scope of the relief we sought. We didn't ask and hold the county absolutely 100% responsible for all the costs they incur. We asked for that preliminary relief, hoping, believing that, gee, the county will wake up, realize that this is what they should do, and call the bond, get the money, and go do the improvements. They have fought us at every turn. We don't have to do this. We have discretion whether to call the bond. We don't have to call the bond, and we don't have to do the improvements. So here we sit before your honors with a minute and a half left and basically saying, totally our discretion. In this instance, Your Honor, no, I don't think they have discretion. I think Norton says that bond is exactly for this purpose, and they have to use it. And in Norton, they even said, the Supreme Court said the city would have to come out of pocket if that assurance wasn't enough. 414.
I was going to say, so the county really has to then use the money, hire a contractor, or do it themselves and complete the infrastructure.
Exactly, Your Honor. And 414 says exactly that. They may do or have done the work and charge the subdivider's bond. So charging the bond's not an option because if you go back to the statute and you look at Norton, the purpose of the whole bond is so that the taxpayers don't pay the money. And whether it's the taxpayers or it's the lot buyer, that's not fair to the citizens of Coconino County to impose an obligation that the Empire had and paid for, and the county holds in its hand but refuses to use. And instead says, gosh, you bought the lots, hey, you took on this liability. Folks, Belmont is not a subdivider. It never took on the obligation to put in the subdivision improvements that are defined in the ordinance. It never did. All it did was buy the lots in the subdivision. Just like
It did more than that. It bought them with the intent to construct homes on them and sell them.
Absolutely.
Are you making this argument that they're just property owners?
Absolutely, Your Honor. They are. I could buy a house. I could buy a lot out there and build a house on it too.
A subdivider under the state statute, 322101 subsection 55 or 56, and the ordinance defines a subdivider as someone, and it's stated in the disjunctive, who wants to purchase lots and sell them to the public. Isn't that what your client's doing?
No, Your Honor. No. These lots have already been subdivided. That's a distinction.
But you want to sell them. You want to construct homes and sell them, right?
Yes, Your Honor, we do. We bought them in a subdivision that was already completed and final plat approved. That vested rights in those lots so that anybody could buy them. A public report could be issued. Any person could go out and buy those lots and build a home on them. The fact that whoever is on title to those lots shouldn't matter because they're not a subdivider. That subdivision has already occurred, and those rights are vested in the lot. So if I went and bought a lot out there, it shouldn't matter if it's in my name or if I formed an LLC to put it in or if my client Belmont buys them to build houses. We're all going to build houses. That's exactly what the zoning for that subdivision is. Thank you, Your Honor.
Thank you, counsel. Starkey.
In the court's questioning, Mr. Freeman was repeatedly pressed on the issue of isn't he asking the county to build out infrastructure in situations when it would be absurd to do so, when the subdivision's in the middle of nowhere and nobody would want to live there? In the trial court, we talked about a subdivision plat being approved and then discovering that it was on a terrible earthquake zone or discovering that there was contamination and it was uninhabitable. And Mr. Freeman, when pressed with such hypotheticals, twice in the argument you just heard said, well, they can just revert it. They can just revert it to acreage. That's an easy fix. When Judge Portley asked, could Coconino County revert this subdivision, Mr. Freeman's answer was, I don't think they'd be successful. Well, which is it? Is it an easy fix, or is it something they're not entitled to do? The fact of the matter is, if the county took steps to try and revert this, they would run smack into all sorts of vested rights claims on behalf of the property owner. And there's something called Prop 207, which Arizona's voters approved in 2006. It's codified at ARS Section 12-1134, which says that the county has a monetary liability for any diminution in value that's caused by a new law that affects the right to subdivide. So if the county said, okay, we're just going to revert this and solve the problem that way, there'd be a different lawsuit. And it would be, okay, well then pay us the diminution in value from reverting our property. So it's not an easy fix.
So, counsel, Mr. Freeman was discussing with us sort of the historical setting of the statute being passed, being the mid-'70s, made reference to Ned Warren, I think. And I mean, what are we to make of that? There was a purpose behind this statute. I can see in the argument that one of the purposes of the statute was to ensure that a fly-by-night developer would not get so far in the process and then collect money and then abandon a project.
That is absolutely right, Your Honor. The purpose here was to ensure that consumers get infrastructure when they buy residential lots. The purpose was not to impose, to make local government a guarantor for the real estate industry.
Yes, but the statute provides, and in this instance, the county has required these bond funds to be segregated, apparently for the benefit of this subdivision.
No, there are no funds. I mean, there's a bond that the county is the sole beneficiary of.
Bond obligation.
Right.
Which will translate into funds. And the argument here is that the county is dismissing that and ignoring it and instead chooses to force a subsequent developer or group of individuals who wish to build homes to come up with new funding for the infrastructure.
The county only has a bond funds, proceeds of the bond, once the surety pays. And in order to get there, the county has to initiate and prevail in civil litigation. Let me step back, Judge Winthrop, because I think that the argument on the other side is a play on the word ensure, because it does appear in 821. It says that counties shall adopt subdivision regulations that require bonds so as to ensure completion. If the legislature had intended to say that it is the responsibility of local government to ensure that the subdivision gets built, the infrastructure gets built in every subdivision they approve, any Wednesday night council meeting, they would have said that. The word ensure has to be read in the context of the entire statute. It's like an enabling statute that said the county shall adopt a building code to ensure building safety.
Well,
okay,
this
that's
seems
great.
to say ensure the installation of required street, sewer, electric, etc. That seems to be fairly specific.
No, it's specific in requiring the substantive provisions of the county subdivision ordinance, which Coconino County complied with when it adopted the Coconino County subdivision ordinance. It didn't mean to direct or constrain the discretion that operates in any given situation for all the reasons we've discussed. If you wanted to say you must always call the bond, and if the bond company won't pay or goes insolvent, then roll the trucks because you're going to be building out those streets and sewers and sidewalks, they would have said that. And you would see that in the financial statements for the last 30 years. And you'd see city and county attorneys saying, think carefully before you approve this subdivision because we're on the hook for the whole master plan community if they go belly up. And it just never worked that way. And that's the league's brief. That's what's so alarming.
What's the value of the tool then of the surety bond? What is the value then?
The value is if it is there as an emergency source of money, if the government says, in our discretion, this is a time to step up. For whatever reason, we didn't budget for this, it's not our ordinary course of business, but this is an emergency, that we need disaster relief. Then here's a source of funding to be used. That's what the bond is for. Thank you.
Thank you, counsel. We appreciate the spirited argument. It's very informative. We're going to take this matter under advisement and and issue a ruling in due course. And with that, we are adjourned.